So you guys are kind of like the pioneers in this process of talking about errors, telling the family about the error, finding out the cause of the error, and compensating the patient if, in fact, there was harm done due to substandard care.
Yes, we are the epicenter of this kind of bullshit. You're exactly right, Rick.
Hey, I don't think, honestly, come on, you didn't mean to say that. It just came out. You know,
Yeah.
you didn't. It just came out.
Let me just say this: you can't half start one of these programs. You either do it or you don't, because not every doctor is trained to talk to patients about things that went wrong.
Oh, yeah. Listen, those doctors, probably the hospitals that I know of who do this, they've got people who are trained to tell patients about adverse outcomes and who do it in some kind of way rather than, I've never been trained in this. I have no experience at it, and I basically screwed it up. So listen, here's an article I got for you. It's entitled Outcomes in Two Massachusetts Hospital Systems Give Reason for Optimism About Communication and Resolution Programs. That's kind of the generic word for this kind of stuff. The main idea here is to disclose adverse events to patients, investigate the cause, explain what happened by somebody who can do it appropriately, apologize, and proactively offer compensation where substandard care caused harm. So this is a study out of Beth Israel Deaconess Hospital and two community hospitals associated with it, and Bay State Medical Center with two of its hospitals. So all in all, it was 6 hospitals. It took place in 2012. It should be noted that Massachusetts law required adverse disclosure. So it's not something that you can decide whether you're going to do or not. AMA basically says adverse disclosure is something that should be done. Here's now a state saying you have to disclose adverse problems. And in addition, they provide legal protection if you make some statements of apology. And we've talked about that in the past, where some places where you make a statement of apology that can be used to go against you in court. And other states have said they're called apology laws, which basically say you cannot enter that into court to suggest that the people are guilty.
By the way, the apology laws are also referred to as I'm sorry statutes. And basically what they say is saying I'm sorry is not the same as saying I'm guilty. And what at least 37 states want to do is make sure that doctors will talk to patients about what went wrong and that it is not fodder for trial.
I'm sorry.
Yeah, right, exactly.
So sorry. Who sang that?
Sorry. I'm sorry I brought that turn up.
Hey,
that was Connie Francis, by the way.
I don't know, but it's
Google
for air.
Google it.
Hey, listen. There's another part of this law. So basically, there's the apology part where you can't use it against the folks who apologize in court. Number 2, catch this, Greg. Defendants, basically, you have to, if you're going to sue somebody, you have to tell that people you're going to sue that you're going to file in 6 months. There's a 6-month gap in there where it is hoped that there's the opportunity to settle and resolve the disputes between the parties. Right. So that's really amazing, because that means that this lawyer has to sit on this thing for 6 months while the hospital and other people, I guess, tried to kind of resolve this thing. I think it's a reflection of the fact that we don't want to take this stuff to court. That's not the place to settle this stuff.
Well, this is not unique to Massachusetts. Michigan has a 180-day notification period that we're reviewing the case, and in the next 180 days, we have to file this case. So I think that it is not uncommon that there's a time of cooling off, rethinking, discussion before you actually have to have a lawsuit filed. And that, at least in the University of Michigan situation, they have reduced greater than 50% the actual cases that go on to lawsuit at the University of Michigan Hospital.
Hey, well, listen, why don't you read or review the results of the study that I just outlined at these 6 hospitals with regards to their events and how it came out economically?
Well, bottom line is during the 2013-2015 timeframe, there were 989 events reported. Now, we don't divide this up as to how many of these are emergency medicine. Right. So we can't comment on that. 26% were noted to have violated the standard of care. And at least a quarter of the cases, there was some harm to the patient. 91% of adverse events did not meet compensation eligibility criteria. So I'm not sure exactly what that means, Rick, but what I think this means is they wouldn't necessarily have been given money.
If there was substandard care, it did not result in any harm. There's various permutations of that, but ultimately, patient harm is kind of the common denominator here.
Right.
Tell us about payments now.
Well, median payments in those that met compensation eligibility got an average of $75,000.
That's petty cash.
Well, that's what we call that now. Yes, and maximum offer given in here was $2 million. Can
you imagine the hospital saying we are going to offer you $2 million because of whatever they did? That's a pretty substantial sum, but it's certainly probably a lot less than may have been gotten in a court battle.
Well, the other thing is, and here's the number out of this entire study that I think is worth commenting on. Only 5% of events led to malpractice claims or actual lawsuits. 5%. I mean, that's pretty good. What that means is 95% got resolved in some way, shape, or form. I think we can handle that. That's probably pretty reasonable. What it doesn't say is of those 5% that went on to claims or lawsuits, what happened in those cases? Did they win? Did they lose? We don't know. But, having run 2 insurance companies, it's the grease of the system, the costs of litigating that grind you down. During my time settling cases, more than 50% of the money went to the grease of the system. Less than 50% went to actually injured parties. So if you can cut that down to 5%, you've really cut a lot of fat out of the system.
Well, what Dr. Boothman started at the University of Michigan has spread out, especially when states now say you have to report adverse events.
Yes.
So that took away the, do we want to do it? Do we not want to do it? And there are a whole bunch of systems out there that said this is going to be the way we worked even before there was a law. But this is a success story. I think that you'd have to agree. And it seems like common sense. Communication, apology, and resolution is what these programs are called. And I think any hospital worth its salt's got to have something like this going.
Yeah. Again, my only warning is, and the university found this out, make sure you have the right personality doing the communication. That means you may not want the second-year resident in neurosurgery.
Oh, God, no.
Yeah, talking to the family.
No, you want to, once there's something that looks like it's going to be a problem, you want to notify the people who are authorized to do this as quickly as possible. Unfortunately, it can't do it 24/7, and there are things where there's an adverse event that occurs immediately, and you have to respond to it. So that I think everybody in the hospital on the clinician side needs to be aware of, or maybe have some training in this idea of communication and apology.
I think it has to be done in a timely manner, but I don't want to see our residents running down the hallway into someone's room saying, "Oh my God, I killed your mother." That's not the way to handle this situation. I've got good news and bad news. I killed your mother, but the lady in the next room wants to buy her clothes. Don't do that sort of thing. Yeah.